By using the term fair, I don't mean that it's okay to cheat. What I do mean is that you want the fight over before it begins. There have been lots of illusions about trial law and combat. This is one that works. If you are in a firefight, you do not want to win the firefight with the last shot. You want to win the firefight with the first shot. It's the safest way to get home. Trials are front-end loaded. That is, the first thing that happens in a trial is the most important thing in the trial. If you are in a jurisdiction where you are allowed to participate in jury selection, that is probably the most important part of the trial. Obviously, you can do a better job if you are preaching to the choir than if you are swimming upstream the entire trial. So if you are able to have some influence in picking jurors who will listen to your story and your theory of the case, you're going to be in a lot better position. But many of us practice in jurisdictions where we don't get to participate in jury selection. And throughout your career, if you are young enough and you're going to practice for the next 30 or 40 years, you may well live to see the day where lawyers are simply excluded from jury selection. And that becomes a complete function of the judge and the court. And so your first opportunity to deal with the jury, to influence the jury, is in opening statement. And so it's opening statement that I want to talk to you about today, and the theory of the case. But mainly I want to talk to you about opening statement. When I said fair fight, what I mean is that you want your first shot at the jury to be one of overwhelming importance, that is persuasive through preparation, investigation, knowledge of the case, and then, I suppose, experience, which you're beginning to get today. A knowledge of the way that juries operate, what they think about, and transitioning from being what you may think a lawyer really is, or what a lawyer really does, to becoming that type of a lawyer who understands that what lawyers really are in jury trials is a 13th juror. That we think like jurors, that we talk like jurors, that we adopt the mindsets of jurors, and from that we develop the theories of our case and the way that we present them to the jury. There is a way that you can use opening statement to win your case. It would be nice if after the opening statement, although you can't leave and go home at that time with the victory, because there are still mechanical processes such as the evidence, final argument, and the charge to the jury and their deliberations that have to be gone through. There is a way that emotionally with the jury you may have already won, that they have already decided the case in your favor. The key, well, the vehicle that we talk about for delivering a powerful opening statement is the vehicle of storytelling. It is not just the primary vehicle for opening statement. It is the way you should look at the whole trial. It is the primary vehicle for direct examination. Interspersed with argument, it's the primary vehicle for your closing argument. Storytelling is not the primary vehicle of cross-examination. That's the one place that storytelling generally does not apply in a trial. Otherwise, Storytelling is what we do as lawyers, as trial lawyers. How do we get jurors to listen to us? If they will listen to you in your opening statement, you stand a very, very good chance of winning the trial. But they must listen to you from the beginning of your opening statement to the end of your opening statement. How many of you have seen an opening statement in a trial before? How many of you thought it was boring? You can go to the courthouse today. You can go as soon as you finish this court, listen to an opening statement, and 9 times out of 10, maybe more than that, you are going to hear something that is truly awful. Something that will cause you to shut down in the first few minutes. Your mind will wander off. You will not be engaged with the lawyer who is doing something like presenting a roadmap, giving an overview, all of which is pure waste of time. How do we get jurors to listen to us? What makes them want to listen to us? They don't know us. They don't trust us. They don't even like us. And if you're the defense lawyer, they particularly don't like you in a criminal case. What can you do to overcome that? Tell them a good story. That's what you can do. You can tell them the story of your case. Now, one of the things that we had prepared for you this morning was a wonderful PowerPoint presentation that's right here in my computer. And if you would like to see it after I talk, you can come up and go through it with me, because we can't get it to sync with the projector. So it remains a wonderful secret PowerPoint presentation that I worked on all day yesterday, and really does, I mean, things zoom in from the side and they come in from the top and they stack on each other. It's really, I did have problems. My big problem last year was I misspelled trial. I misspelled it as trail. Somebody noticed that. Fortunately for all of us, trail preparation is a lot like trial preparation. And so, you know, it was, we were well covered on, in case you got, as a trial lawyer, got stuck out in the wilderness, you could prepare your trail. What's the law of opening? What's an opening statement about? Come on. You're going to give one in just a few minutes. What are you going to talk about? Anybody? You going to talk about the law? Judge Blumenfeld.
Not in my courtroom.
Not in his courtroom. As soon as I mention the law, what happens? That's right. You're going to argue your case to the jury? Judge Blumenfeld. Mm-mm. What's left? What are you going to talk about? The what? The facts. The facts in the case. That's all you are going to talk about in opening statement, is the facts in the case. No argument, no law. You got an assault case. It involves self-defense. As soon as you start to explain the law of self-defense, Judge Blumenfeld stops you. The law comes from the bench, not from the lawyers. The best way to talk about the law of self-defense to a jury in opening statement is to never use the words. Talk about the story that gives rise to the justification of self-defense. Well, let's talk about how to get prepared for an opening statement. You know, it's best to view that there is a classic way of trial preparation. And even though I have tried over the years to find a better way, I really can't find a better way to prepare for trial than to reverse the order of the trial itself and prepare it backwards. What are the parts of the trial? What's the first thing that happens? You've got to select a jury. So it's jury selection first. Next thing, what are we doing today? Opening statement. What's the third part of the trial? The evidence. Plaintiff, defense, state, defense, government defense, depending on what kind of case you're in. What's the fourth thing? The evidence is closed. What happens next? Argument. Final thing, charge to the jury. That's it. There's 5 parts to the trial. So when you prepare, you just prepare backwards. The first thing that we do to prepare for trial is to go get the jury charge or create the jury charge. You can go to a jury charge book and find it, maybe. You might be able to simply go to the secretary or judicial aide or court coordinator for the particular court where you're going to try the case and ask that person if they have a charge that's been used in a similar case. Get it? It's one the judge has used before. It doesn't mean you don't have to look at it closely to make sure it's correct, but it gives you an idea of what that judge has accepted before. So there's a shortcut that you can use to go get the charge for the case. Why is the charge important? Well, the charge is like the narrowest part of an hourglass. It defines what the jury it defines relevancy is what it really does for you. It defines what is relevant to your case. Everything must fit through that jury charge or it doesn't get to the jury. The next thing that you have, your next folder, whether it's a virtual folder on a computer or a real folder, is final argument. Final argument, though it's fun, and it's what most of us are very good at when we first get out of law school, is, in my opinion, the least important part of the trial. Why? Why is it the least important part of the trial? What do you know about jurors? Anybody? Yeah. That's right. They've already made up their mind. Most of the time, they've already made up their mind before final argument. Doesn't mean you get to skimp on it. It just means you got to realize that trials are front-end loaded. The important things, the truly important things in a trial happen up front. There are very, very few lawyers in the history of this nation who were able to win trials in final argument. And you're not one of them. And you probably never will be one of them. If you have to skimp or scrimp or save time on something, save it on final argument, put that time over into the opening statement, and you will win more cases. Third part, in your third folder, may have a bunch of different parts to it. It's the evidence. It's the government's evidence. It's your evidence. In those evidence folders, there ought to be a page for every witness, or maybe a folder for every witness. You have a folder for opening statement. What do we do with all these folders? What goes into these folders? How do you know? You know, when you're in law school, you got a class, you got a semester, you got a certain amount of time, you come up to final exams, and you know you got to work on this exam at a certain time. Maybe you got a day to work on it, maybe half a day to really study hard for it. With trials, they may evolve over a year, 2 years. There may be that much time in preparation before you get to trial. During that time, from the time that you first get that case until the time that you step into the courtroom, you will, from time to time, will have thoughts about the case. When are you going to have those thoughts about the case? When are you going to have that brilliant thought about the case? Come on. You know when you're going to have that brilliant thought about the case, don't you? Where are you going to be? You're going to be in your office, at your desk, thinking about this case? Bullshit. That's not where you're going to be. You're going to be in the bathroom. You're going to be in a cab. You're going to be someplace that is terribly inconvenient. It'll be the middle of the night. A system of trial preparation can be as simple as just a pad and pencil that you carry around with you if you train yourself to use it. I tried this with an electronic deal, and I'm just no good at it. So the pad and pencil works for me. You have this brilliant thought, you write it down, you forget it. No, you write it down, you take the piece of paper, you put it in the folder that you created at the beginning of your case. We're talking about a system of trial preparation, a simple system of trial preparation that you can use starting today and for all of your career, that doesn't break down, that works for every trial. You write down your thought and you put it in the appropriate folder. Maybe it's a wonderful statement for opening. Maybe it goes in a number of folders. Maybe it's a question on cross-examination for a police officer. And maybe it needs to go into that police officer's folder, it needs to go into final argument, and it needs to go into opening. Big deal. Put it in all three. There's one trick to this method of trial preparation, and that is when you write down your brilliant thought at 3 o'clock in the morning, you do not censor yourself. Do not censor yourself. Take the thought, write it down, tear it out, put it in the folder, forget about it. Go on to something else. A different case. Your personal life. It doesn't make any difference. Write it down, put it in the folder, and forget about it. 2 weeks before trial, when it comes time to really prepare, now you're going to have to block out some time to look at this stuff. And you may have a folder that's, if you're like me, it's just got pieces of paper. They're all different colors. Some of them are torn off. Some of them are nice and clean like this. Some of them have more than one thought on them. I mean, it's a mess in there. It's just a mess. Now's the time you censor. Now's the time you start looking at those thoughts. You say, God, I can't say that. That's awful. Jeez, whatever made me think of that? On the other hand, that thought, which you threw in that folder a year ago and thought wasn't very important, I don't know whether this will work or not. A year later, 2 weeks from trial, seems brilliant. Why? Because you know so much more about the case now. The investigation has gone forward. You've learned more facts. Other things have come up. This thought from a year ago, which you might have thought a year ago was too stupid or unworthy of you, being brilliant as you are, now is truly meaningful. Had you censored yourself a year ago because you thought you knew what this trial was going to look like a year from now, you would have done yourself a terrible disservice. So the trick is, at the time that you get the thought, you don't censor it, you put it in the folder, you leave it there, you forget about it, and then you go back and review everything that you've got, the good and the bad, and begin to form your theory of the case from there. That system, primitive, simple, portable, you can move it around with you, you can put it on your computer, it works. It works for everybody. It's not difficult. And it doesn't change. All right. What is the theory of the case? What are we trying to do when we talk about a theory of the case? As a trial lawyer, not as a law student, not as a law professor, not as a judge, but as an advocate before a jury. Talking about a legal theory? You have an assault case. Your client hit somebody. You've listened to the story, and from your knowledge of the law, you think that maybe there is a self-defense justification in this case for your client. You look at the law of self-defense. It says something like, from the defendant's point of view, the defendant felt it was immediately necessary to use the force to prevent an immediate harm. That's your theory of the case? The legal theory. What about a factual theory of the case? You study the facts. You know the facts. You know the facts in detail. Your client stepped out of a bar onto the sidewalk. There were words with somebody that he didn't know. The person took a step toward him. After he took that step toward him, he was within a distance that he could reach him. Your client perceived a threatening gesture on the part of this other person and immediately reacted and hit him. It's the only blow that was landed. Your client is charged with assault. It's a factual defense. What is it that we're really looking for with the jury? You could explain the law to them. Well, you couldn't in Judge Blumenfeld's court. You couldn't in most courts. And aside from that, whether you could or you couldn't, you don't want to, because the law is inherently boring. It bores people. It bores me. It bores jurors. They don't want to deal with. That's not what jurors do. They aren't lawyers. They don't deal with the law very well. You know, there was a report that came out this fall in some newspaper, astounding. It's as if they just tripped over it. It was this finding that 80% of the jurors don't understand the jury charge. Hello? I mean, we've known that for years. They've never understood the jury charge. In many, many trials, they can't get through half of it. They just put it aside. It's too thick. It's not interesting. It's not who they are. What's the theory? What is it you're looking to hook up with this jury on? You're looking for an emotional theory for them. That's how they decide the case. You know, they didn't go to law school. They're not these people who went into a law school program as real human beings and came out as square pegs pounded through a round hole. They didn't come out as people who can pile fact upon logical fact upon logical fact, leading to an inevitable conclusion, as we can do. They can't do that. They don't think that way. They are not linear thinkers like we are, thank God. But we are linear thinkers. That's the way we think. So we have to accept that that's the way we think and then get around it. To try to put into words an emotional, or put into words, or give an emotional value to the theory that we are trying to get across to this jury. What might be the theory in the self-defense case that would connect with the jury? It could be a lot of things. What would you want to know? Something about the person that he hit? Maybe there's something there. Let's find out. Does this person have a violent background? Who started this thing? Who said what to whom first? They stepped out of a bar. Had somebody been drinking? Lots of facts could begin to play into this. The emotional theory could end up being from your client's point of view, fear. He hit him because he was afraid. It could end up being that the guy just needed a good beating. Now may seem a little strange to you, but that theory, the guy just needed a good beating, is a theory that has been used forever in murder cases. That what the deceased needed was just a good killing. And when do you use it? I saw a hell of a trial attorney about 25 years ago float a self-defense for a defendant who shot a guy in the back of the head 5 times and then reloaded and shot him again. From the back seat to the front seat at a drive-in movie, and the jury bought it because the son of a bitch just needed a good killing. He was a bad son of a bitch. And that theory worked, and the jury bought it because the jury thought the defendant had done a service to society by killing that guy. And that was the emotional theory. And that lawyer knew it. So what you are digging for here is the emotional theory, that which gets down and grabs them in the gut, because that's where jurors think. They think in their gut. They don't think up here in their head like we do. And if you stay in your head and be the logical lawyer that we all are, you're not going to connect with these people. How do you find that emotional theory? Well, it's not a lawyer thing. It's not something that you go to law school about. It is what makes you passionate about the case. What is it that makes you angry about this case? What makes you laugh about the case? What brings on some emotion in you about the case that you have been brought, that your client has brought to you? Is there something that eventually gets to you? If you get down to 3 or 4 months from trial, and you've been working on this case, and there's nothing, absolutely nothing there, you need to think about some alternatives, like settlement or giving the case to somebody else. Because if you don't have something that makes you passionate, something that makes you care about the case, you're not going to be able to transfer it to the people on the jury, to the people you're selling it to. Caring on your part about your case, caring is contagious. If you care, they will see that you care. They will feel it. If you don't care, they'll know it immediately. Okay. One of the things, I'm going to go through some aspects of theory of the case, and I'm going to go through them rather quickly because, to tell you the truth, I find talks about theory of the case to be very boring. I've never seen it done well, and I don't do it well. A good theory of the case reconciles inconsistencies. You don't want to get in a trial and fight about everything. That's not the object of a trial. What you want to do is focus on that which is most important. Save your fights. Save the firepower for where it really counts. But don't fight about everything that's collateral. So your theory of the case should reconcile as many things as possible. It makes sense out of the most facts. It ends up being tight and tidy. In fact, I think what every trial lawyer should strive to do. By the way, in the 5 parts of the trial, where does the theory of the case, where would it be the most appropriate to lodge the theory of the case? As you begin the development and the final trial strategy, where do you want that theory to show up as a singular place? Actually, no. The closing. I know why you say the opening, because it comes first. But remember, when we prepare the trial, we prepare it backwards. So we're preparing the last thing first. Jury charge is simply a guide. The final argument is where your theory is developed. And it's important that it's developed there because in the preparation, we're doing that right up front. We're doing the preparation of the final argument before we prepare jury selection, before we prepare opening statement, and before we prepare the evidence, that is, the questions, direct and cross-examination. Why? Why do we do it that way? So we know where we're going. You got to know where you're going. If you don't know where you're going, any road will get you there. If you don't know where you're going, you don't need a theory. You can just stand up and wing it. Your theory is in your final argument. And the best thing for you to do to understand how important this theory is to boil the theory down to a sentence. Can you boil your theory of the case down to a single sentence? A single sentence with no lawyer words in it, a single sentence with no semicolons, a single sentence with no great big words, a single sentence with words that jurors can understand, and then you can tweak it a little. And from there you can put flesh back on the bones. But it's important for us to go through exercises like condensing it down and making it simple. You know, one of the things that you strive for as a trial lawyer is to make it simple, to make it understandable. I love the phrase complex litigation. I love and hate the phrase complex litigation. Complex litigation is great for making a lot of money, I think. But it's worthless if that's what you really think you do. It better not be complex when you get before the jury. It better be pretty simple. If it's complex, those people who are buying the story, those people who are going to decide guilt or innocence or decide how much money you get to take home at the end of the day, are not going to be buying anything because they won't understand it. So the theory of the case is tight and tidy. It's simple. Boil it down to one sentence. It reconciles as many inconsistencies in the case as it possibly can. But the most important thing is that it is the emotional basis. Louis Nizer, who I think, at least from what I have read, was one of the great trial lawyers in this city, along with Aaron Stoyer. Who did the Triangle Shirtwaist Factory? Aaron Stoyer. In the preface to one of his early books, I think it was My Life in Court, talks about something called the rule of probabilities. This is what he says the rule of probabilities is, and it was the rule of probabilities guided Nizer in coming to his theory of the case. He said that from experience, from our experience, we can anticipate how people will react to a given set of circumstances. From that, he said that if conduct, or a story, is implausible, it must be rejected. It doesn't mean that your client comes to you and tells you the implausible story, right? And it doesn't mean that you don't go out and investigate it and take a look at it. You do. I don't think it's very wise for you as a lawyer business person to say, that's bullshit. Don't believe it. It's not good. It's not good for attorney-client relations. It's not good for business. But as you sit there as the lawyer and listen to your client tell you the implausible story, what's going on in your gut? What are you saying to yourself? Ooh, I sure would hate to try to float that story by a jury. That one doesn't pass the smell test. I don't like that story. What's wrong with that story? It may not make a lot of difference what's wrong with that story. The important thing is that you feel in your gut that that story doesn't work, that you don't like it, that it hits you the wrong way. That is the rule of probabilities at work inside of you. The story doesn't work. The rule of probabilities, as Nizer used it as important because it wasn't something he developed as the way a lawyer needs to think. He developed it because he felt it was the way that jurors thought. That's the way that jurors decided cases. Was that they just, look, what are we talking about? We're talking about jurors applying their common sense to a set of facts. That's all. How is it expressed by jurors? When the trial is at an end and the jury goes back into the guilty room to decide the case, what kind of questions do jurors ask back there among themselves when you, the lawyer, are not present to answer those questions? Can you believe so-and-so? Well, that is certainly not a question that you want a juror asking the other jurors about your key witness or your defendant or your theory of the case. And because you don't want them asking that question, can you believe? You have to ask it first. This question of plausibility can have to do with the witness's story. It can have to do with the witness himself or herself. Classic example. In the prosecution of a sexual assault case, the inexperienced prosecutor. Let's take a type of assault, a sexual assault case that gets bandied about in newspapers once in a while, and that is that there is a focus on the way that the victim was dressed the night of the assault. Something that particularly defense lawyers, male or female, better leave alone. On the other hand, that is, you leave it alone as far as any type of comments from you. It is going to come out in the evidence. So let's say that the victim was dressed in a short skirt and a halter top, and she was sexually assaulted. The inexperienced prosecutor, when it comes time for trial, brings the victim to court dressed in a communion dress. Well, maybe communion dress doesn't work real well here. A white pinafore. But the story is not of a woman in a white pinafore, is it? The story is of people drinking beer in a pool hall and the real world. And the jurors go back in the jury room and somebody asks the question. Some juror asks the question because they don't know better. They're not lawyers. They weren't taught that they're not supposed to comment on this stuff, that it could be offensive. They don't know that. And so what does some juror say? He doesn't know any better. She doesn't know any better. What's the question? Can you believe what? Can you believe the way she was dressed in there? Now what's happened? What's happened to that witness? What's happened to the entire prosecution story at that point? The plausibility of the witness, not the witness's story, the plausibility of the witness herself has taken a hit. Her credibility has taken a hit simply because of a lapse of common sense on the part of the prosecutor. It's a tough question. How does the prosecutor dress the victim? I don't know, but not that way. You don't come into court wearing the clothes that you wore that night, but you don't come into court wearing the white gloves either. It doesn't work. Common sense tells you a lot of the answers to the theory of the case. Okay. Let's talk about opening statement. When you do things this morning, you're probably not going to do them this way. Those of you who want to be real trial lawyers are going to do a very real trial lawyer thing at lunch, and that is you're going to skip it. And you're going to use the lunchtime to rework your opening statement, to give it a shot, to try it this way, just to see if it works. Maybe it won't work for you. Maybe it will. But one of the tricks to this course is that somebody on this faculty gives you a suggestion. Do it a different way. Try this. And you have the guts to take the time to actually try it. See if it works. See if it feels good. See if you can make it work for you as soon as possible. We're talking about storytelling. Opening statement is the story of the facts of your case. There's something important about this. We are not all great storytellers yet. You will be. But as you sit there, you are all great story listeners. All of you love good stories. We do. We grew up on stories. It is natural to us. It makes us comfortable. Yet you hear a good story, you get sucked into it. You use your imagination. It's fun. You go with the storyteller. Storytelling does things for us. Between a storyteller and a listening audience, there are bridges that are built. There are bonds that are forged. Trust is given. These are all things that are important to trial lawyers. And these are things that you can accomplish using storytelling in opening statement the very first time you get on your feet in front of the jury, to create trust, to forge a relationship with these people that is not a forced relationship, that is a relationship that is very natural. People like good stories, and they like good storytellers. Let's talk about actual tools of storytelling. The single most important tool for you to remember about telling a story, about telling a story to a jury, is to stay in the past tense. Michael and I, last year, watched the demos. Are they today on opening? The first day. And one of the people who was demonstrating last year, it was really remarkable because we were standing over here by this door watching. And the woman who was doing the demonstration was just mesmerizing for 15 minutes. Her opening statement was a half hour long. For 15 minutes, she was mesmerizing, and then as if somebody completely shut the valve off, it stopped. And she was boring. And you could look at people out there, and Michael and I looked at each other. I said, what's happened here? We looked out here. People got restless. They started moving around. And we figured out in about a minute that what had happened was, in the first 15 minutes, she had stayed in the past tense. She was talking about the story that was told by the facts in the case. And then all of a sudden, she switched over into the reality of the courtroom and started using those artificial phrases like, then we will call so-and-so who will tell you that, or the evidence will show. Famous lawyer phrases from opening statement that you should never use. But you will this morning, won't you? Don't worry about it. What I don't want you to do is use it this afternoon. Use it this morning. Don't use it this afternoon. Stay in the past tense. If you stay in the past tense in opening statement, you almost force yourself to tell the story. Can you think of stories that are told in the future tense? Might be interesting to try, but look, a jury trial is not avant-garde. It is not a place to get Fellini-esque. Do it the traditional way, okay? Juries don't get that. Stay in the past tense. Here's another secret tool for opening statement. Write it out. Heresy to a trial lawyer. Write it out? Well, you don't get to bring it into the courtroom and read it. Write it out is a step in preparation. Write it out word for word. What happens when you write it out word for word? Among other things, you get to check the tense. Is it all in the past tense? You get to see if you're using those phrases like, and then the evidence will show, and then we will call officer so-and-so who will take this stand and say that. What's wrong with that? What's wrong with talking about somebody's going to take the stand and say such and such? Nothing really wrong with it. The problem is that it's not very comfortable for jurors. Look, most jurors don't want to be there, okay? Some do. I mean, you'll encounter the juror who comes with their little brown bag lunch, and you know they're really ready to be a juror. This is the most exciting thing that's happened to them in a long time. Beware of that juror. Be very afraid of that juror. Most of them don't want to be there. They got other things to do. And they're right. A large part of trials are very boring. They are not comfortable in the courtroom. It's not a comfortable place for them. It's a lot like being in the first grade. They're told where to sit. They're told how to behave. They are forced into learning through their ears, when that's not the way we learn. We learn through our eyes mostly. We're very visual. And, you know, most of what's going on in a courtroom is oral or oral. Write it out. Computers are great for this because now we can take paragraphs, and when we write it out and we see that something's out of order, we can take the whole paragraph and just put it someplace else. One of the great things about computers. Whereas when I started out, it was the old cut and paste. You know, you had your computer consisted of your scissors, your yellow pads, your stapler, and your Scotch tape, and your Scotch tape, and your Scotch tape. And we cut it and we pasted it, and you know, and it just took forever. It was not a bad exercise. Having hands-on, having to get your hands on the paper and get the scissors out and cut it and move it and so forth is not a bad exercise at all. It really gets you into moving things around and makes you understand where it goes. But the computer can do the same thing. Good trial lawyers will spend an inordinate amount of time on the first sentence of opening statement. They don't want to have a lousy first sentence. That first sentence needs to go out and grab those jurors by the throat and bring them up in your face. And it says, this is important, pay attention. The first sentence of opening statement is not, ladies and gentlemen, my name is Bill Allison. I'm the defense lawyer in this case. We already know who you are, or they don't really care. This part of the trial is called opening statement. And what opening statement is a roadmap to the evidence. Oh, yeah? Well, this is just fascinating. That's not a good opening statement. So go ahead and cross that out. Is there anything left there for you to open on? Good trial lawyers spend a long time on that first sentence. They think about it. They invest in it. They may also invest a lot of time in the last sentence of opening statement. And the last sentence of opening statement, it is difficult. It is difficult to stay in the past tense on the last sentence of your opening statement, and so you can break that rule. But you have a great opportunity on the last sentence of opening statement. You don't have to stay in the past tense, because the classic last sentence of opening statement is, at the end of this trial, I'm going to come back to you and ask you for a verdict of guilty. Okay? Don't do that. At the end of this trial, I'm going to come back and ask you for a verdict of not guilty. Don't do that. You could say to the jurors, at the end of this trial, you will have heard all of the evidence, and you will agree that the evidence supports a verdict of. Now that's better. Why is that better? How about this? How about this one? At the end of this trial, you'll know in your hearts what the right answer is. And each of you will do the right thing. Do you trust the jury enough to do that? You don't know these people. You better. They're the only jury you got. You don't have any other choice. That's who's going to decide the case. You might as well tell them that you trust them, whether you trust them or not. I don't like asking them for a verdict. I think that works against you. I think what it essentially says to them is that you don't trust them enough to make up their own minds. And I think it is time that you back away from that at the end of your opening statement and give it to them. That's what they're there for. Tell them you trust them. Okay. Avoid, in opening statement, the use of the word I or we. First of all, it's unethical. If at any time during the trial where you want to use I or we, you need to go to the judge, raise your right hand, be sworn, and take that witness stand, because you're about to testify. I think. I know. It won't work. But aside from the fact that the judge is going to shut you down, embarrass you a little bit, if you do that, it's not good advocacy, and it is totally inconsistent with telling a story in the past tense. Why? Because you weren't there. You aren't part of this story. You are the storyteller. The story just comes through you to them. But you're not part of it. I and we have no place in that story. Get rid of it. Final thing I want to say about storytelling is a tendency that we as lawyers have throughout the trial. But it is, I think, most detrimental in the opening statement. And most detrimental in the opening statement because the opening statement can be so powerful as a tool for winning a case. Look, let's be honest about what we're trying to do here. We are trying to poison these people's minds early. And there's nothing fair about this. You're not cheating. You're not lying. You're not stealing. You're just better prepared using a better tool, better weapons, better tactics, better strategy. we tend to want to talk to jurors in terms of conclusions, in terms of superlatives, instead of describing in great detail a fact or a setting, a situation, and letting the jurors come to the conclusion that you want them to come to. It stems from the fact that we don't trust the jury. We want to tell the jurors what to think. But it's not good lawyering. It's not good advocacy. The good advocacy is that you describe in great detail something that is in fact superlative, and they come to the conclusion that it was the greatest. The snow ended at 4 o'clock on Saturday, and we went to Central Park, and it was just gorgeous. It was the most beautiful scene I have ever seen. The snow ended at 4 on Saturday. That entrance to Central Park, right by the Plaza Hotel, the one that goes down the hill by the big rock formation, was crowded. There were hundreds and hundreds of people on that path. They were shoulder to shoulder. And they were all happy. Not a cross word was spoken or heard. Everything was pristine. It glistened. And the sounds were muted. And as the light faded, it seemed as though the snow held on to a portion of that light and kept giving it back in a magical way. And you could go on and talk about that. But you're talking about describing detail to the jury and letting them come to the decision. And we want to say to the jury, so-and-so really loved, Timmy's grandfather really loved his grandson. Instead, what you want to do is to paint the picture for them. How about this? Every day after school, now this was back when Timmy was in the second grade. Every day after school, when school was out, about 3 o'clock, Timmy would go to his grandfather's house. His grandfather was always there for him. And his grandfather would have for Tim, he would have cookies and some milk, and they would sit at the small kitchen table. And Timmy's grandfather listened to him. He listened to Timmy tell him about his day. And he let Timmy describe things. And he asked Timmy questions. And they would talk about things that were important in Timmy's life. And they would talk until it was time for him to go to his mother's apartment. Now, from that description, I'm going to let you decide what the relationship between Timmy and his grandfather was. But I'm going to build that relationship in a factual way so that you come to the decision that there was great love and respect between Timmy and his grandfather, particularly going from Timmy to his grandfather. I want you, as the jurors, to come to that decision. I want you to make that conclusion, because if you make that conclusion, it's yours. You own it. You've defined it. You have made the decision. Nothing I or any other lawyer in the courtroom say is going to break you away from that, because you've invented that love. On the other hand, if I, as the lawyer, tell you about that love, that's my opinion. And I'm a lawyer, and jurors don't like lawyers, and they don't trust them, and they shouldn't trust them for good reason. So when I tell you the conclusion, the natural reaction of jurors is to discount it, to want to reject it. But if I describe the underlying scene to you in great detail and let you come to the conclusions, you own those conclusions. That's your mind coming to the conclusion and not mine. And that is a true lawyer's skill. Back away from the conclusions, describe in great detail the underlying factual situation, paint the word picture, and the jurors will come to the right conclusion. They just will. They will come to the right conclusion. A couple of final things about opening statement. Objections. By and large, avoid them. Here's why. Most of the stuff that you're objecting to in opening statement is bad lawyering. Suppose that a lawyer gets up in an opening statement and does talk about the law. Do you care? Nobody's listening. It's boring. Suppose he even misquotes the law. Again, let him go. Resist that temptation to make that objection. Now listen, having said that, let me tell you something for purposes of this course. In the day-to-day classroom stuff that we do, go ahead and make the objection. Because one of the things that we try to teach here is the art of objecting, but we don't have a day that's devoted, or a morning or an afternoon. It's every day that's devoted to that. And the art of objecting comes in two steps. The first step is to be able to recognize that which is objectionable. If you cannot recognize that which is objectionable, the tactics of objecting, you never get there. Do I object or do I not object is totally irrelevant if you don't recognize something going wrong. So this morning, if you catch somebody arguing, if you catch somebody talking about the law, if you catch them doing anything other than talking about the facts, go ahead and make the objection, simply to hear yourself make the objection. It's good practice on the recognition front. On the days that you do trials, which is Sunday, and then Sunday and Monday of the following week. Put them together. Play it like a real trial. There you need to do the recognition and then take the split second to decide, do I want to make this objection? Do I not want to make this objection? Is it worth it? And many times in opening statement, it's simply not worth it. You may underscore something that you don't want to underscore, but the main thing is that if somebody's doing a bad opening statement, talking about the law, making conclusions, arguing and so forth, it by and large is not working. So let them go. Visuals. I used to think that visuals in opening statements were good. I don't anymore. There is an exception, and that is distance and direction. If you've got a case, such as the Marilyn Miller case, Potter versus Schreckle, where you've got an intersection, and you've got distance and direction involved, nobody can follow distance and direction. I'm a guy. I think I know it all about distance and direction. I get totally lost when people start talking about distance and direction. I do it today. I've been doing this for 30 years. I still get lost when a cop gets up and says, well, it was 15 feet southeast of the intersection of so-and-so. I'm gone. I've lost it. So there is an exception. In opening statement, if you need to use a diagram for distance and direction, go ahead and use it. But use it. Incorporate that diagram into your story in the past tense. You go to it, you illustrate something on it, pointing When you are through with the diagram, take the diagram down and turn it around. If you don't, what do the jurors do? They keep watching the diagram because we are so used to learning through our eyes that they will keep watching this thing and trying to build their own story on the board up there because it's visual, and they'll stop listening to you. And you lose your power as a storyteller, as an Imagineer, as the person who is conducting their imagination. So use the visual, put it down, and get back to your story. I think that's it. Thank you.